That Duch, the former almighty director or head, as he has been described, of S21, would return to S21 in the faced by the survivors and the guards, that he would return there between two policemen and two co-investigating judges. Who could have thought such a thing possible? On the proposal of his lawyers, he agreed. And he said to us then, yes, I will go to Guek with the judges and the prosecutors. Yes, I shall go to S21. But I ask two things of you. First, I would like to have some time to myself, with no one present, all alone. And the co-investigating judges granted him that time alone. And he said again, I would like to be afforded the right to speak to the victims who will be present and to the guards of S21, that is, the former guards. You will see now the victims who were not, the victims who were not present at this reenactment. During these proceedings, you will see the film of this reenactment, and you will have the opportunity to see the tears he shed, the tears that were shed between the victims and Duch when he spoke to them. Who can say that at that time none of them were honest? It is also that aspect that is also the major advantage of legal proceedings. What other than justice, or what other than a judicial system, could have organized this meeting between Duch and his former victims?
Yes. No matter what may be the tragedy that you have described, that the co-prosecutors have described this morning, a tragedy that has obviously arouses all of our compassion for the innocent victims. No matter this tragedy, I would like that we also, 30 years afterwards, I would like that we have a thought for the one who today is confronting his past. I am repeating this. It is necessary to have a certain amount of courage. I'm even going to go further with this. What allows a man who is confronting all of this, what allows him still today to remain alive? If it is not because he is convinced that he still has a role to play in humanity, by requesting, by asking forgiveness from the victims, by addressing himself to his people, by addressing himself to the young people, to tell them, this is it, this is what we have done, this is what we fell into, this is what you should never repeat. So, yes, of course. Yes, Your Honors, the co-prosecutors, Duch remains a human being. Maybe there are certain points with which he has a bit of trouble admitting certain things. Of course. But maybe that you as well, you have trouble admitting certain things on his behalf. The hearings will prove to you that maybe you are also in the wrong somewhere when you say to the chamber, we want to present the book that Duch wrote, which is the work of his life. And you will understand that it is not he who wrote the book. Sometimes you can be in the wrong, even co-prosecutors. And you can, when you are accused, to be mistaken in your good faith, but you can also have a bit of trouble admitting certain things that are extremely painful. So, I would like to repeat one more time that these hearings are going to allow us to go even further. We have the opportunity in this court for the first time before international criminal justice to have civil parties. Ladies and gentlemen from the civil parties, you have your full place in these hearings. You will be able to ask Duch the questions that you wish to ask him. And as the Council of Ministers said, that will be the honor of this justice, to allow this encounter. Unfortunately, I prefer warning you right away. There will not be, not all of the answers will be given to all of your questions. Your main question, and I am aware of this, is why? Why all of this? I am not sure that Duch on his own has the answer to this tragic question. Why? Why all of this? Why? Why these scenes, these unthinkable scenes, unbearable scenes at S21? Why? Why these scenes that dehumanize the victims, but who also dehumanized at the same time those who perpetrated these atrocities? Will we be able, at the end of these hearings, to be able to return to the victims all of their humanity, but to also be able to allow those, or the one who had exited humanity, to return to humanity? This is the stake for our court. Thank you.
The President, the trial chamber would like to inform that regarding the request by the co-prosecutor to respond to the defense counsel, your request is not granted because based on the content of our schedule, this process is not the proceedings where evidence is presented. It's only just the beginning of the proceeding. Next, we move to the other item concerning the agreed facts or uncontested facts. I may ask the prosecutors whether you have already agreed on some facts with the defense counsel.
Thank you, Mr. President. With your leave, however, I'd like to correct what is obviously a misinterpretation of my earlier comment. I did not ask for a right to respond to the defense presentation. What I asked for was the right to make an observation, because what I believe happened earlier was the presentation of a motion by the defense challenging the jurisdiction of this court over the accused, the constitutionality of the proceedings of this court, and indeed qualifying those proceedings as an affront to the national sovereignty. Now, in my culture, when a lawyer stands up, he is presumed
the President, I would like the co-prosecutor to go straight to the point. The trial chamber asked you to clarify concerning the uncontested facts because your request to make observation has already been rejected.
Thank you for that clarification, Mr. President. I note that there is later in the agenda a point for other business, and I will certainly return, with your permission, of course, to that other business. We have indeed, at least on this, an agreement. If I may. In response to Your Honor's request on 5 February 2009, the co-prosecutors on 11 February 2009 supplied... What? Oh. We have a technical problem.
Pada traduction,
I apologize. I think having these things close to the mic is probably not the best idea. As I said, on 11 February 2009, we supplied the defense with 351 factual allegations, facts, derived from the first three parts of the indictment, as amended, of course, by the PTC. We provided these facts in English, Khmer, and French. The first part covered the summary of the facts. The second part, the legal characterization of the facts. And thirdly, the character of the accused. I'm sorry. Now, when we say that these facts were derived from the indictment, for the most part, they were in fact taken word for word from the indictment. Cut and paste. In some cases, there has been some editing to exclude references to evidence or to remove things that we, the co-prosecutors, did not agree to, and various other editing measures. The Honours will note that with the exception of the dispositive part of the indictment, that indictment contained only 171 paragraphs, yet 351 facts were submitted to the defense. This is because, as you know, each paragraph contained, many facts, sometimes a lot. So these paragraphs, therefore, were split into individual factual allegations to allow the defense to state a definitive position on each of the individual facts contained in any one paragraph. This agreed facts document proposal was given to the defense, as I said, in all three languages. And the defense was asked to record on this document whether the defense agreed, partly agreed, disagreed, or did not dispute any of these 351 facts. The defense response was received by the co-prosecutors on 19 March 2009 in French, and then on 26 March 2009, last Thursday, in Khmer. The defense in its response addressed two out of the three main parts of the indictment. They did not respond to the legal qualification of Part 3 that we submitted. Regarding Part 1 of the indictment, the summary of facts, it contained 262 individual factual allegations, and the defense responded with, in fact, 351 distinct individual positions on these facts, as some of the allegations initially put forth contained multiple parts and were therefore responded to individually. In short, the defense responded in two ways, either with a qualification or comment regarding a fact, or without any comment. Now, regarding those responses or qualifications or comment by the defense, 157 allegations were agreed to by the defense. 81 allegations were not disputed, and 21 allegations were disagreed with. Obviously, if I make a mistake in the numbers, I'm sure my learned friend will correct those. So to sum up, the co-prosecutors and the defense have agreed to 157 of the 350 factual allegations in Part 1. Additionally, the defense is not contesting 81 of those facts. Therefore, 238 out of 351 facts are not being contested during the trial. Regarding the remaining 112 of the 351, they have either not been agreed to, or alternatively, they have been agreed, partly agreed, or not disputed with some comments. Now, due to the defense qualification of some of these facts, the co-prosecutors are not in a position to agree to the qualified facts. And obviously, whatever a fact or a factual allegation is to be contested, it will be done as appropriately during the stages of the trial that you have set forth. Now, I don't propose to read into the record all the single facts that has been agreed to. I could, if would you leave, if you want me to, but I'd rather not. Instead, I submit that the defense could and will, I believe, submit very shortly and file into the record the details of which allegations of fact it agrees with, disagreed, comments, etc. Obviously, as I said, the ones that were put forth and that are agreed, not disputed, or not commented, can be deemed by this chamber to be agreed between the parties and not contested. Obviously, we are all very much aware that this agreement between the defense and the prosecution does not bind you in any way whatsoever about these facts. That is quite clear. This agreement was put forth as a trial management tool to indicate to the chamber where the debate lays between the parties. It will come as no surprise that most, as I assume the defense will file, that most of the disputed facts rest with the part of the indictment dealing with the responsibility of the accused. But, however, as I said, most of these facts, these factual allegations, have been admitted to or not contested or not commented on. The reference number for this filing, I submit, will be E5/11/2. And I would, as I said, I have indication to believe that this will be done shortly into the record so that the chamber is aware of the agreed facts. I, of course, stand ready to answer any questions or provide any clarification.
President. Coming next, I would like to invite the Defense Counsel to state your position concerning what raised by the co-prosecutors regarding the agreement on the facts. If you would like to make any comments concerning this matter, the floor is yours.
Monsieur le Président,
Mr. the President, ladies and gentlemen, I agree with the comments of my colleague from the OCP. We therefore suggest that we pass on to you tomorrow through official channels the work that has been completed by Duch himself and his lawyers concerning the acknowledgement of the facts that has been proposed by the co-prosecutors. We have worked in the following way. Each time the accused agrees with a paragraph, we have mentioned in red, okay, we agree, and there are a few paragraphs on which the accused has indicated that he agrees partially, and therefore he explained why he only agreed partially. And you will see as well that a certain number of points are not contested, challenged, and will not be challenged during the trial. And then we have each time under the paragraphs, you will see this in blue in our version, we included the paragraph of the indictment to which this paragraph in the prosecutor's document corresponds to, because we understood that the co-prosecutors went over the indictment or the closing order and broke down the closing order, and in order to have more clarity, we have mentioned to you which paragraph of the closing order this corresponds to. But we also added, sometimes in green, and you'll see this in our document in green, we also indicated we indicated the terms that the co-prosecutors did not attend to. That is, sometimes the co-prosecutors in their work just made summaries of the closing order. So sometimes we would like to add the text itself of the closing order. So we have added this paragraph in green because for reasons of clarity, Duch prefers that the totality of the paragraph in the closing order be specified. And all of this is indicated in our document, so therefore we suggest that we give to you this document and also an explanatory note explaining how we went about this. And in substance, as my learned colleague Robert Petit said, the vast majority of the factual elements are accepted, and we have, of course, certain disagreements on certain points that the hearings will make clear. And therefore, tomorrow morning we will be able to transmit to you through official channels.